In 2008, Mr. Hassan, a Somali citizen who had engaged in piratical acts, was captured by French military and held hostage 6 days and 17 hours under the control of French authorities, inter alia and international waters, before being held in additional 48 hours police custody upon arrival in France. The European Court of Human Rights decided that the suspect should have been brought before a judge immediately after entering French territory, and more importantly, that a procedure as prescribed by the law was not given due to the mere absence of any rule in regard to the conditions of the deprivation of liberty in the case of Mr. Hassan. The domestic legal system in France did not provide any protection against arbitrary interference with the right to liberty and security through French authorities. In the last decades, violence against ships off the coast of Somalia increased dramatically, leading to serious calls for additional rules and regulations both domestically and internationally to counter maritime piracy. The Gulf of Aden is an essential gateway for all transits through the Suez Canal, linking Europe with the Middle East, East Africa, and South and East Asia. 95% of the trade of all states of the European Union passages through the Gulf of Aden, and Somali piracy leads to economic losses of $18 billion annually in the global context. The concept of piracy is legally coded through Article 101 of the UN Law of the Sea Convention, UNCLOS. Here, piracy is defined as any act of violence, detention, or depredation that is committed for private ends and that takes place on the high seas or outside of the jurisdiction of any state by passengers of one private vessel against persons, property, or vessels aboard. This definition highlights two factors. First, the crime of piracy is committed for private ends. Second, it is defined by the space in which it occurs, namely the high seas that are outside the jurisdiction of any state. The first feature is regularly questioned in academics. Can piracy also be politically motivated? And if it was, which implications would derive from that motivation? The common answer to that question is the stressing of the irrelevance of the subjective motivation of pirates. Private ends refer to the opposite of public, not the opposite of political ends. While military actors like the EU naval force depend on a clear distinction between economics and politics for the distinction of policing and warfare in the area, other voices call for the definition of piracy as armed conflict to attack piracy gangs on land and use extended military force in accordance to international humanitarian law, which would place pirates more into the category of terrorists and therefore deprive them from their basic rights as civilians. Both of these notions, however, try to define piracy in regard to the political action and military force that is imposed on pirates, failing to consider that the question of piracy is not one of mere definition of legalities, but rather a question of justice and the lack thereof in pirate-prone Somalia. On the one hand, many Somali pirates stress to be motivated by the political aim to protect the natural resources of their country. In the last decades, Somalia experienced illegal overfishing by Western industrial shipping vessels and the illegal dumping of toxic waste in its waters. Somali piracy, through that lens, then gets a political, anti-imperial dimension that is completely disregarded in the common discourse to conceal the strong Western impact on the apparent failure of the country by design. Human rights violations in the question of Somalia did not start with piracy. They end there. On the other hand, strong evidence suggests a connection with the economic situation of many Somalis today, as industrial shipping vessels removed a significant source of income from coastal communities. Piracy, then, can be defined as a reaction to such negative economic shocks. The unemployment rate in Somalia is one of the highest in the world. 67% of people between the age of 14 and 29 are unemployed. Simultaneously, 67% of the Somalian population is under the age of 25. That isn't so far interesting, as especially children and juveniles got recruited by piracy gangs, with poverty being a main factor for piratical acts. While pirates are generally defined as enemies of all mankind, inherently evil, this portrayal is, for example, reflected in several UN resolutions calling for the use of all necessary measures by all states to combat piracy and UNCLOS itself. The reality so commonly overseen is that of mere children, robbed of a future by the same authorities that now punish them for holding on to the last straw of possible income they have. Under this aspect, the treatment of suspects appears fundamentally problematic. Article 105 of UNCLOS allows for people to be arrested by pure suspicion. Suspects, if prosecuted, are either transported to the country of the authority that captured them, or brought to neighboring countries like Kenya, which has transfer agreements with Western actors like the EU. The transfer itself conflicts with the right to liberty and the principle of non-refoulement. Under international refugee law, a state is not allowed to expel a refugee into states where his life or freedom would be threatened on account of certain characteristics he carries, for example, a particular social group or political opinion. Here, the question of definition becomes prevalent again. Whether a Somali pirate can be regarded as a refugee is another question. However, the fact that some European governments abstain from arresting suspects to avoid asylum claims once more underlines the moral, rather than legal responsibility at play. Furthermore, although Western states seek governmental assurances to seemingly guarantee for the well-treatment of suspects in Kenyan prisons, there are numerous allegations of torture and challenges to provide prisoners with legal safeguards against the Kenyan legal system. Transportation to Western states poses different troubles to the suspects. Somali pirates prosecuted in Germany were reportedly homesick, depressed, and attempted suicide in the new environment they were forced into. The innocence of many pirates, as opposed to the painted picture of universal criminals, becomes furthermore evident when considering the fact that some defendants were released from custody and attended German schools afterwards. The act of piracy is mainly described as utterly immoral through the space it is committed in. Not only are the high seas a domain outside the jurisdiction of any state, but also a place where natural forces join the equation, leading to further complications. Concepts like the piratical paradigm argue that it is mainly that space that defines the problem stemming from piracy. The attempt to govern from beyond the geographical authority of any government reveals its impossibility through the treatment of suspected pirates. But is the reaching of dead ends in the international legal system enough to define young men with severe economic grievances as outside of it, and therefore as lost causes undeserving of universal protection? Does piracy in the end really comes close to other crimes under universal jurisdiction, such as genocide and crimes against humanity? Or is the treatment of Somali pirates rather an indicator of Western suppression of the paradoxical relationship of land sovereignty at sea and the cover-up of serious human rights violations committed against the Somali people for decades? France updated its law for a judge to take a decision on the further arrest of a suspect of piracy within 48 hours after an arrest at sea. But such as terrorism, piracy is not a phenomenon to be erased through legal definitions and illegal prosecutions. The Somali population has to be considered in an imperial system that constantly stands against them. Who is more vulnerable here? The young Somali pirates or the trading vessels that pass through the Gulf of Aden?